welcome all. In this lecture, we are going to talk about intellectual property rights. The subject is Pharmaceutical Jurisprudence, code is BP 505T. So, introduction to IPR. IPR stands for Intellectual Property Right. Okay. So, what is intellect? Intellect is any creation of the brain. Okay, any creation of the brain is known as intellect. Okay. So, sorry, intellect means creation of brain means any ideas, any information, any innovation, okay, that all comes from brain. So, all those information which is new is known as intellect, and if that intellect or these creations have a commercial values, based upon this, if we have a commercial value of that idea, commercial means a business model can be developed based upon that information or that creation, then that is known as property. Okay. As these creation are belonging to an individual, so the individual, they are the rights of that particular individual, and hence the word coined as intellectual property right. Okay. So, intellect is the idea, the creation of the brain, because it has created wealth, or it has a uh, promising information, so that it can a wealth can be developed. So, it becomes a property, and since it this idea has created from one person itself, so uska wo right hoga. So, intellect property rights. Okay. Now, intellect property rights are governed by intellectual property law. Now, this is very important कि intellect property law के अंदर ये सारे कुछ आते हैं. Okay. Government of every country grants exclusive rights for the creation, and it is the duty of the holder of the rights to monitor the act of infringement and his rights, as it is believed to increase the country's economy. Okay. So, government of every country, they wants this rights to be protected. Okay. Why? Because if someone has developed very good information, okay, and based upon that, that idea is very creative. So, that person has the right, and government help him or her to protect his right, or his or her right, so that he or she should further involved in creating more and more ideas, and there should not be any copying of those ideas, okay, from other person, so that it can increase country's economy. Now, we will see some history of intellectual property right, when it was required, when it was felt these IPR should be protected, or these IPR law should be made. Okay. So, first of all, initially the inventions were kept secret, okay, so that it is well protected. So, secrecy रहती थी तो उसको protect करके रखते थे. As technology developed, as a matter of national prestige, the inventions were made public. But later on technology जब develop हुई, those secrets has to come out in public domain, so that they can be benefited to the public. So, उसको public करना लगा, लेकिन जब public होने लगी, those secrets were never become secrets, and it was open to all, and anyone can copy those information, and they also make such products that is beneficial to others. But the person who has originally created this may suffer. Okay. So, that was the need. In 1867, Germany received the first genuine recognition as industrial nation. So, in this segment IPR development में सबसे पहला जो हुआ था 1867 में, जर्मनी को फर्स्ट जेन्युइन रिकॉग्निशन दिया था एज इंडस्ट्रियल नेशन, मींस इंडस्ट्रियल नेशन का उसको दर्जा दिया गया. In 1893, BRIP was established to carry out administrative tasks related to IPR. Okay. So, BRIP was formed so that they can take care of all intellectual property rights. Okay. In 1948, GATT agreement came into existence to revive economy of countries by increasing international trades, that is predictable by reducing the tariff. So, in 1948, every country when they indulge in business, they started businessing between themselves, countries to countries. Okay. So, they in 1948 GATT agreement where came into existence, and this has provided the information, this has provided, or we can say facilitate the business of the countries from one country to another country, because they have cut down the tariffs, मतलब taxes को कम किया गया. Okay, so that कि एक country का product दूसरे country में आराम से बेचा जा सके. Okay. In 1967, the name of BIRPI was changed to WIPO. Okay, WIPO, to modernize or for better administration of unions with respect to protection of IP while fully respecting the independency of each union. Okay. So, WIPO was the name WIPO was coined in 1967 to modernize and for better administration of unions with respect to protection of IP, intellectual property. Means further they have provided protection of IP across those countries while fully respecting the independency. Okay, while जो innovator है उसकी independency को secure रखा गया at each union. Okay. In 1995, WTO was established. So, full form of BIRIP is Burex for Protection of Intellectual Property. Okay. GATT is General Agreement on Tariff and Trades. WIPO is World Intellectual Property Organization. The center is in Geneva, Switzerland, and WTO is World Trade Organization. So, this is how the concept of IPR developed from time to time. Now, nature of the intellectual property rights. What is the nature, means what are its इसका quality क्या होती है और इसका nature क्या है. IPR has become an issue of wide and serious discussion with the formation of the General Agreement on Trades aspects of intellectual property rights, that is TRIPS, under urgency round agreement of the GATT. Now, it is known as WTO. Okay. India is in priority watch list of USA under special 301 system. Intellectual property insists on some amount of novelty or originality to gain protection. Okay. So, intellectual property should have some novelty. Novelty means newness. Okay. It should have a newness and originality. The work should be original, should not be copied from anywhere. Then only the intellectual property will gain the protection. The law will only be implicated on for the protection if it has newness, means novelty and originality of the in the work. Intellectual property system is a duration specific. Okay, and intellectual property rights will be given for some duration, say for 20 years, yeah, for 10 years, depending upon case to case, those rights will be given. So, basically IPR is intellectual property rights is whatever the creation human being has, he should able to protect his idea in terms of business. So, that if I have discovered something, so I should only be benefited for some period of time by the government about all the products and manufacturing or the sale of that particular product. Okay. So, but it does not provide perpetual or absolute monopoly over the property, but it does not mean कि ये लंबे टाइम तक, perpetual means it will stay for longer period of time or there will be absolute monopoly, मीन्स हमेशा के लिए अगर मैंने किसी प्रोडक्ट को डिस्कवर किया हुआ, किसी ड्रग को डिस्कवर किया, दैट डजंट मीन कि आई विल बी द ओनर ऑफ दैट ड्रग एंड आई विल ओनली सेल और मैन्युफैक्चर और मेक मनी फ्रॉम आउट ऑफ दैट पर्टिकुलर ड्रग. नो, इट्स नॉट लाइक दैट. ओके, बट यस, what is protected with respect to intellectual property is the use of value of ideas, expressions or expressed ideas. However, the bundle of rights constituting the intellectual property is not over abstract ideas, but rather over physical, concrete and tangible manifestations of these ideas. ओके, सो इट डजंट मीन कि कोई भी वेग आइडिया आया और हम उसको प्रोटेक्ट करेंगे. अनलेस एंड अनटिल इट शुड बी फिजिकल, कंक्रीट, टेंजिबल मैनिफेस्टेशन, मतलब वास्तविक आउटकम उसका अगर है ऑफ दीज आइडियाज, देन ओनली इट कैन बी प्रोटेक्टेड. फॉर एग्जाम्पल, राइट्स अंडर पेटेंट लॉ इंक्लूड राइट्स टू मैन्युफैक्चर, ओके, डिस्ट्रीब्यूट एटसेट्रास. ओके, सो इफ अगर किसी को पेटेंट की IPR मिली हुई है, पेटेंट लॉ के हिसाब से कोई IPR मिला हुआ है, सो उसके पास राइट्स होगा ओनली टू मैन्युफैक्चर एंड डिस्ट्रीब्यूट. ओके, वाइल अगर किसी को कॉपीराइट वाली IPR मिली हुई है, ओके, दैट मीन्स ही हैज द राइट फॉर डिस्ट्रीब्यूशन, पब्लिकेशन of that particular segment. Okay, all of which deal with concrete imbalities of ideas and not the abstract ideas themselves. So abstract ideas का means ये है कि कोई भी vague thought से नहीं होगा. that thought, that idea should be physically concrete and tangible manifestations उसकी होनी चाहिए, then only this will be applicable. Now, what is the constitution aspects of intellectual property? Okay, the constitution plays an important part in helping courts and legislatures arrive at and justify a balance between conflicting rights. Now, what is the role of constitutions? Means the law. Law का क्या use है? Suppose two persons is fighting for same idea कि I have created first, I have created first, and those both wants for this. So the law is required if there is a conflicting rights. Okay, conflicting means opposing rights, means two persons are fighting over the same idea. In that way, the constitution plays an important role in helping courts and legislations. Courts को भी एक guidelines दिया हुआ है कि how to take decision, so that this should justify a balance, okay, between conflicting rights. The US Constitution specifically protects the intellectual property under Article 1(8) by specially providing to promote the progress of science and arts by securing for limited times to authors and inventors the exclusive rights to their respective writing and discoveries. So they have in US they have given the protection to promote and progress, okay, of science and arts. So whenever the idea is related to promotion and progress of science and arts, okay, then the rights will be given to the authors and the inventors. Authors means if they are writing something new, or inventors if something is new invented, exclusively for writing and discoveries. Next is though there is no such intellectual property clause in India Constitution, India में अभी तक कोई इस तरह का constitution नहीं है. There are no constitutional restrictions on the power to make laws on intellectual property. The Constitution for 44th Amendment Act 1978 in India struck off the right to property from the fundamental rights. However, property was made a legal right and was put under the Article 300A in Right to Information Property, which says no person shall be deprived of his property save by authority of law. Now, next we will see IPR classification. So, what are the types of IPR? We will look into this. It can be broadly divided into two parts. One is the industrial property rights and another segment is the copyright and related copyrights and related rights. So, we will see one by one. What do you mean by industrial property right? This is referred to the rights useful for industries and commerce. Examples: inventions, patents हो गया, trademarks, goods and services, industrial design, the design, geographical indication, the plant varieties, integrated circuits, biological diversities. So, these all are industrial property rights, okay. And in this also the law is also written according to this, okay. So, for any patent, the Patent Act 1970 will work. Trademark good and services के लिए काम करती है, the Trademark Act 1999. Industrial design, the Design Act 2000. Geographical indication, geographical indications of goods and act. Plant varieties, the Protection of Plant Varieties and Farmers Rights Act 2001. Integrated circuits, the Semiconductor Integrated Circuit Layout Design Act 2000, and Biological Diversity, Biological Diversity Act 2002. So, these are the industrial property rights. What comes under copyright and related? It basically refers to related to the artistic and literary works, okay, and Copyright Act 1957 works. For example, writing work, musical works, dramatic works, painting, drawing, sculptures, photographic works, architectural works, sound recording, broadcast, etc. These all come under copyrights and related rights, okay. So, IP rights it can be registered or it can be unregistered types also. So, patents, trademark and design, these rights can be registered, and unregistered types of IPR is Copyright, Unregistered Design Act, Common Law Trademarks, Database Right Protection for know-how under laws dealing with confidential information and trade secrets, plant varieties, geographical indication, design of integrated circuit, passing of trade designations. These all comes under unregistered. So, IPR rights further can be divided into registered and unregistered types. So, application of IPR. So, what is the application? When we understand what do you mean by intellectual property rights. So, what is its application? So, types of IPR we have seen. Patents is one type of IPR, okay. So, what is the subject? Should be new, non-obvious industrial application. Should be novel होना चाहिए, non-obvious होना चाहिए, or it has an industrial application. So, patents is applicable to chemicals, drugs, plastics, engine turbines, electronics, industrial control and scientific equipments. So, इस area में अगर हमें काम करना है, then we will get an IPR. The name is patent, okay. Trademarks. Trademarks is what? Signs or symbols to identify goods and services, okay. Trademarks is the so it is the subject matter is signs or symbols to identify goods and services, and it is applicable to all industries, okay. Now, copyright type of IPR is copyright, original works of the authorship. So, written work जैसे printing, entertainment, audio, video, motions pictures, software, broadcasting related issues comes under copyrights, okay. Next is integrated circuits. Integrated circuits means originally layout design, okay. Microelectronic industries, trade secrets, business information. This is applicable to all industries. Another type of IPR is industrial design. For example, subject matter is ornamental design. For example, clothing, automobiles, electronics. If any new design has been introduced, that will come under industrial design. Geographical indications means geographical origin of goods and services, okay. For example, wines, spirits, cheese, okay. Other food products which are grown in that particular area only, okay. That will अगर इस तरह की कोई चीज़ है, that will come under geographical indication rights. So, these all will cover one by one. So, first we will see patents. A patent is a legal title granting its holder the exclusive right to make use of the invention for limited area and time by stopping others from, among others things, making, using or selling without its authorship. If I have created something new, so I have the rights to only manufacture that product, not others should copy, okay. In return of this right, अगर मुझे ये right मिलता है, then the applicant must disclose how his invention works in sufficient detail. Now this is also very important. अगर मैंने ये rights government से ले लिया कि मैं इसको manufacture distribute करेगा, तो in turn what government will ask, you should provide a complete disclose. You have to disclose your all information, invention, okay. When the patent is granted, the applicant becomes the owner of the patent. Like any other form of the property, a patent can be bought, sold or licensed or mortgaged. Okay. So owner मैं बन जाता हूँ उस, अगर कि मेरे पास पेटेंट है, बट आई हैव द चॉइस कि उस प्रॉपर्टी को, वो जो मेरे पास प्रॉपर्टी है, आई कैन सेल दैट प्रॉपर्टी, मैं किसी से खरीद भी सकता हूँ, लाइसेंस पे दे सकता हूँ या मोर्टेज में दे सकता हूँ उसको. पेटेंट्स आर टेरिटोरियल राइट्स. सो an Indian patent will only give owner rights within India and rights to stop other from importing products into India. Okay. So territory rights होती है. If I have discovered something in India, that is applicable in India only, and no one can from outer country, no one can actually import that particular product also. So types of patents. One is the product patent, another is the process patent. Product patent means invention consists of a new drug, okay, and process patent, invention contains of a new method or process of making unknown new drug. So product, one is A plus B has become C. So this is the product. So patent is given on the product, means no one can make this product, okay. So product patent, but A plus B and C, this is process, no one make use of this process to make this product, and another is no one will able to make this product. So product patent, and this is a process patent. So both type of patents is there. So utility patents, types of patents, utility patents, whoever invents or discovers any new or useful process, machine, manufacture, composition of matter or any new useful and improvement thereof may obtain a patent thereof subject to the condition and the requirement of the title. For example, toys, coating, tools, machines, okay, this type or utilize functional form iska, so that will get the patent, and the patent is given for 20 years. Plant patent, whoever invents or discovers the asexually reproduces and distinct the new variety of the plant, including cultivated spores, mutant hybrids, newly formed seedlings other than that of tuber process plant or plant found in an unconvoluted state, can be given as plant patent. Another is design patent, whoever invents any new, original and ornamental design for an article or manufacture may obtain a patent. Non functional में आते हैं ये, for example decoration, apparel or jewelry, okay. So these are the okay. Patentable invention, under the Indian patent law, the patentable invention must be, उसमें चार चीजें होनी चाहिए. It should be novel, second is it should be non obvious, useful, and it should have a industrial application. If these four things are there, then it is patentable invention, you can apply for a patent. अगर ये चारों में से कोई एक भी चीज नहीं है तो applicable नहीं होगा. There are some exceptions कि सारे प्रोडक्ट्स को हम पेटेंट कर सकते हैं कि नहीं, नो, there are some exceptions. Some invention in spite of being new, non obvious and useful cannot be patented. So what are those inventions which are injurious to public health? जो injurious to public health है और violate public morality, public interest and causes serious injury to human, animals and plants, they cannot be patented. Second, new methods of agriculture or horticulture is non-patentable in order to have widespread benefits such as inventions rather than constraining to the commercial gains. Means कोई भी agriculture से related अगर कोई method आपने नया develop किया हुआ है, you cannot patent because public का उसमें फ़ायदा ज़्यादा दिख रहा है rather than कि उसको patent देना होता है. Okay? A process of treatment of human beings and animals, plants cannot be treated as patent. Okay. A mere discovery of a new form of unknown substance which does not have a result of enhancement of efficacy means इसका मतलब है it should be new, product should be new and all those 4 parameters should be there, then only it will apply for patent. The mere discovery of a scientific principle or the formation of an abstract theory and discovery of anything, if we have discovered a new molecule or discovered a new bacteria, this though they are already there, but you have discovered new, but nature में वो exist कर रहा है पहले से, that cannot be patented. Okay, any invention which in effect is traditional knowledge, or where an aggregation or duplication of known property or traditionally known components cannot be patented. Any process of medicinal, surgical, curative, prophylactic, diagnostic, therapeutic and other treatment of human beings, or any process of the similar treatment of animals render them from free diseases, increases their economic values, that cannot be patented. Okay. Investigation related to atomic energies, कोई भी research और atomic energies से related है, that cannot be patented. Plants and animals in whole or any part thereof other than microorganisms, but including seeds, varieties, species, essentially biological process for production, propagation of the plants, this cannot be patented. Any mathematical or business methods or computer programming, जैसे algorithm if you have developed, cannot be patented. The mere scheme of rules or method of performing the mental act, कोई भी mental act आपने create किया, जैसे for example method of playing games. Okay, if you have discovered a new game of method, so that cannot be patented. Okay, so these are the few information regarding what is patented and what is not to be patented. So, the basic things we need to understand is the patent is the IPR is basically patents, trademark, copyrights, integrated circuits, trade secrets, industrial design, geographical indication. Okay. So, these are very important. If you understand IPR, to know IPR, it should be patents क्या होते हैं, then trademark उसमें क्या होते हैं, copyrights, you should able to differentiate patents. So, we have covered the patents part now, and in the later on classes we will see in more detail about trademarks, copyrights, integrated circuits, trade secrets, industrial design and others parts. So, with this information I am going to end this. Thank you so much.